Thank you, Professor Moran, Provost Moran. I'd like to start by saying that I'm delighted to be here today, except that I'm not. And I'd like to start by saying how much I support and respect all those faculty, staff, and students who are boycotting today's event. I think that that is also a very important form of speech. A couple days ago, the Oxford English Dictionary announced the word of the year, and it's post-truth. It's relating to or denoting circumstances in which objective facts are less influential in shaping public opinion than appeals to emotion and personal belief. So I worry about the ways that post-truth claims have been affecting public discussions around Bill C-16, around the Ontario Human Rights Code, and around freedom of expression. There have been some profound, that's not part of my time, that little correction. There have been some profound misunderstandings circulating about the law, and I'm here today as a lawyer, as a law professor, as a civil libertarian, as an expert in equality rights and freedom of expression to try to correct those misunderstandings. So let's start with Bill C-16, which passed third reading yesterday in the House. It's the proposed federal legislation that does three things. First, it adds gender identity and expression to the Canadian Human Rights Code. It will prevent the Canadian government, federal agencies, and businesses within federal jurisdiction, which are quite limited, banks, telecoms, airlines, from discriminating on the basis of gender identity and expression. This is hardly unprecedented. Indeed, the federal government is late to this game. Starting in 2002 and moving forward, the Northwest Territories, Manitoba, Ontario, Nova Scotia, Prince Edward Island, Newfoundland, Saskatchewan, Alberta, Quebec, and British Columbia have already passed these protections. Ontario has had these since 2002. The federal government here is simply playing catch-up. There is absolutely nothing unprecedented in this. Number two, Bill C-16 adds gender identity and gender expression to provisions in the criminal code that define an identifiable group for the purposes of advocating genocide, the public incitement of hatred, and the willful promotion of hatred. So how might these provisions affect the use of pronouns? And do these provisions in any way criminalize the use or misuse of pronouns? Not even close. First, it is absolutely not advocating genocide. Now, unless one wants to start talking about we should kill all the X's, then that's advocating genocide. But pronoun use, nowhere close. Public incitement of hatred. Well, the provisions of the criminal code requires that the incitement is likely to lead to a breach of the peace. Now, does that sound subjective? Well, the Supreme Court of Canada has said there's a very clear definition. The threshold is violence. In fact, there has to be personal violence. It is an extremely high threshold. And again, the misuse of pronouns doesn't come anywhere close. Finally, the willful promotion of hatred, so-called hate speech provisions. Now, hate speech provisions in the criminal code have a very, very high threshold. The Supreme Court of Canada has repeatedly defined hate speech as only including the most extreme forms of speech. The court has said over and over again, and I quote, it is, quote, the unusually strong and deep-felt emotions of vilification and detestation. The court has said it is not disdain, it is not dislike, it is not offense. Plus, something that's often lost, hate speech criminal charges cannot be laid without the approval of the Attorney General. So this is a high threshold. They are very difficult charges to bring. Third, Bill C-16 adds gender identity and expression to the provisions of the criminal code that deal with sentencing for hate crimes. Now here, under this particular section, 718(2)(a)(1), we tend to be concerned about numbers. Evidence that an offense is motivated by bias, prejudice, or hatred can be taken into account in sentencing. We already take a range of things into account: race, national and ethnic origin, religion, sex, age, and others. So now, evidence of hatred on the basis of gender identity and expression could be taken into account. It's important to emphasize, Section 718 does not create any new offenses. It simply means that any existing offense in the criminal code, like assault or sexual assault or murder, if it's motivated by hatred, could be given an increased sentence. This has no impact on pronouns, unless, of course, an accused was misusing pronouns while assaulting, sexually assaulting, or murdering someone. In other words, there's nothing in Bill C-16 that comes close to criminalizing the misuse of pronouns. Nothing. Not hate speech, not hate crime. Now let's look at the Ontario Human Rights Code. So, the Ontario Human Rights Code is a provincial law that protects individuals from discrimination in housing, employment, services, vocational associations, and contracts. It's not constitutional law, which limits government action. It's not criminal law, where the state prosecutes individuals and sends them to jail. It's a type of civil law where private individuals can sue one another. And the remedy is generally damages. The Ontario Human Rights Code was first passed in 1962. It protects people from all kinds of discrimination. It protects people from being fired on the basis of their race, or it protects people from being denied housing on the basis of their religion, or it protects people from being called the N-word or any other racial epithet in the delivery of services like a university classroom. Since 2012, the Ontario Human Rights Code has prohibited discrimination and harassment on the basis of gender identity and expression. It prevents discrimination and harassment against trans and gender non-binary individuals in employment, housing, and services. So what does this require in relation to pronouns? According to the Ontario Human Rights Commission's policy, section 7.4, it specifically said that refusing to refer to a person by their self-identified name or proper pronoun could constitute gender-based harassment. And as a result of some Q&As that were released yesterday by the Commission, clarifying this question of gender pronoun use, they stated the following. Refusing to refer to a trans person by their chosen name and a personal pronoun that matches their gender identity or purposely misgendering will likely be discrimination when it takes place in a social arena covered by the code, including employment, housing, services, like education. What about gender-neutral pronouns? Well, the Commission has said the Ontario Human Rights Code does not require any particular gender-neutral pronoun. If in doubt, ask the person how they wish to be addressed. Use they if you don't know, or simply use their chosen name. So, what it seems to require is the use of he, she, or they. And if you don't like that, then you can always just use their name. There is no question of the 31 flavors that has been put out there that is somehow being mandated. This is about he, she, they, or if you don't like it, use a person's name. Some questions have arisen about this. Is this the first time that a law has decided what we must say as opposed to what we cannot say? No, not at all, not even close. It's not uncommon for the law to require expression. Bilingual labeling requirements on food packaging, health warnings on cigarette packages, the oath of allegiance to the Queen that must be sworn at citizenship ceremonies. Not only is forced expression not new, there's an entire chapter dedicated to it in Peter Hogg's Constitutional Law of Canada. Now, for those of you who don't know who Peter Hogg is, in law we usually we refer to him in a hushed voice. He is the leading authoritative, it is the leading authoritative text in Canadian constitutional law by Canada's preeminent constitutional scholar and lawyer. Okay, so is it constitutional? Now, are these requirements around pronouns constitutional? Does the requirement to not misgender the pronouns violate freedom of expression under Section 2B of the Canadian Charter of Rights and Freedoms? Probably it does. The Supreme Court of Canada says any restriction on speech is a prima facie violation of Section 2B. But the thing is, that's not the end of the story. The charter rights are not absolute. No charter rights are absolute. There's this whole other section in the charter called Section 1, which says that all rights and freedoms are subject to reasonable limits as are demonstrably justifiable in a free and democratic society. The Supreme Court of Canada has developed a very complex test through which it balances rights on the one hand and reasonable limits on the other. This is what the Supreme Court of Canada does in charter cases. And the Supreme Court of Canada has, on numerous occasions, considered whether restrictions on speech contained in human rights codes are constitutional. It has consistently, and I have to emphasize consistently, held that although any speech restrictions that are contained in a human rights code may violate Section 2B of the Charter, they are a reasonable limit within the meaning of Section 1. They held this in the case of Ross, in the case of Taylor, and most recently, unanimously, by the court in 2013. I have a little thing then about why all this matters. And I'm out of time, but why it all matters is because people matter. And I worry that we've moved into a place now, a kind of not only a post-truth politics, but a kind of post-empathy politics, where we no longer seem to care about people. And this, at the end of the day, is about people. It's about trans and gender non-binary people. These are our children, our siblings, our nieces, our nephews. These are our friends, our neighbors, our colleagues, our lawyers, our carpenters, and our teachers. How bloody hard is it to simply treat these people with respect and dignity? Because all this is about, all human rights are about, is respect and dignity. And if you could throw in a little kindness on the top, that would be even better.
Thank you very much, Professor Kosman. And now we will go back. So remember I said after we do the first section, we're going to go back to Professor Peterson. And on this section, we're going to focus a little bit more on academic freedom, gender diversity, and some of the implications for scholarship and teaching. So Professor Peterson, I'd invite you to go first again. 10 minutes, we'll have our excellent timekeeper back there. Thank you.
So I'm going to read you something that a graduate student sent me from the University of Toronto the other day, and I can also tell you that I've received hundreds of letters like this. Today, I had a tutorial at the University of Toronto where I talked about Jordan Peterson and issues of personal identity, legally sanctioned identity categories, etc. I brought up a video of a tall white man in his 30s who asked students at a university how they'd react if he told them he identified as a woman, as black, as short, and as 5 years old. Spoiler alert. Students in the video resist some of the later categories a bit, but are mostly accepting. Still, students were not engaging in discussion. I asked them why. One said it was because she was worried to share her opinion for fear of being singled out or saying something offensive. I asked who else was not speaking for that reason. The whole class put their hands up. That was shocking to me. I encouraged them to speak despite their worries, and they gave me some good feedback on how to make it easier for them to do so. For instance, by working in pairs and being assigned an opinion so that they didn't have to be responsible for it or feel bad for defending it. No participation. Why? They weren't uninterested. They were afraid to speak their minds. The PC police are in your heads. You just heard a lawyer's opinion. I have many lawyers' opinions, by the way. I'll start with lawyer one, who was the counsel to several prime ministers. He talked to me about the Human Rights Tribunal because I went and saw him 2 weeks after this all started. Human Rights Tribunal is a kangaroo court, in my opinion, and it should be abolished as fast as possible. It's one of the many institutions in Canada that pose a threat to your freedom that is of almost unimaginable proportions. Here's what this top lawyer told me. If I'm taken in front of the Human Rights Tribunal, it will cost me $250,000. I will pay the legal costs for my opponents, and I will lose. He said, go back to your safe little life and shut your mouth. Second lawyer told me, my critique of the Ontario Human Rights Commission is spot on. And absent the Charter of Rights and Freedoms, which has these contradictions built into it that you just heard described, much of what I was saying was illegal and has been illegal since 2012. Lawyer 3 told me that if I breached a tribunal order, so imagine I was taken in front of the Human Rights Tribunal and I was fined and then I refused to pay the fine, which I've stated that I would do. That equals contempt of court, which inevitably means jail until the contempt is purged. he told me the social justice tribunals, and that's the technical name of these essentially extrajudicial bodies in Ontario, by the way, the social justice tribunals. So the PC authoritarian types aren't even trying to hide their terminology anymore. The social justice tribunals and the SJWs, social justice warriors who staff them, have a rogue nature. They can search your house without a warrant. They can use secret hearings. There are no rules of evidence, and the judges are unaccountable. Your worst fears of the effect of a poorly written law will manifest in that environment. The SJWs say only the worst of the worst will get punished. Think again. With them at the helm, anything can and does happen. But those are legal opinions. Let's look at a real world case. Let's look at what happened when I made my videos. Let's look at how the university responded, because I can tell you, in the video I said, look, what I'm doing is probably illegal, and worse, my employer is legally responsible for it, because that's built into the codes as well. So by the way, if you're an employer, you're responsible for everything that your employees say, and everything that anybody interprets what they said as being, whether it's unintentional or intentional, whether or not a complaint has been made. So just think about that. Anyways, October 3rd, the university said, like all members of the university community, I have an obligation to comply with the law, including the provisions of the Ontario Human Rights Code. Their policy with regards to workplace harassment, which the university implied that I was engaging in a course of vexatious comment or conduct, where the course of comment or conduct is known, or ought reasonably be known, to be unwelcome. That was the October 3rd letter, which was sent to me within 1 week of posting my videos. And it was the first. So what happened essentially was the university reviewed what I had done, and then they reviewed the policies as laid out on the Ontario Human Rights Commission website, where you guys can all go read them, by the way, and then you can decide if the legal information that you were just provided with is in any degree whatsoever accurate, because I would say it isn't. The university reviewed my videos, and they decided that what I said was true. They decided that the video I made was probably illegal and that they were responsible for it. And so in an attempt to distance themselves from me, under counsel from their legal people, and believe me, the university has good legal people, they sent me a warning. And this is what happens if you want to discipline a recalcitrant employee, essentially, so that you don't have to bear legal responsibility for their acts. You send them a warning to show that you're not in favor of what they're doing. Then if they continue, you send them another warning. And then if they continue, you send them a third warning. And after the third warning, you can take further steps. Now, I pointed out to the university at one point when we were discussing how this forum was going to proceed, that perhaps it would be in their best interests to not support the people who are trying to stop me from talking, but instead to support me legally, and if necessary, to take this all the way to the Supreme Court. And the university said categorically that they would not do that. So I would say, when it comes to the contradictory provisions that are in the Canadian Charter of Rights and Freedoms, and so we might say roughly equality versus freedom of speech, the university decided which side they're going to go down on. And you know, people tell you all the time that this has to do with compassion, you know, and it's obviously the case that all of the compassion in this discussion is on the side of the people who are encouraging their listeners to play victim and perpetrator. And I can tell you, as a psychoanalytically oriented psychologist, that there's nothing more horrible for children and developing people than an excessive compassion, right? That's the standard Freudian devouring mother. And if you want a little archetype to go along with that, I suppose most of you have seen The Little Mermaid. Remember Ursula? Ursula wants to put King Poseidon's soul in a little jar in her collection, and she wants to take away Ariel's voice so she can't establish herself as a conscious being in the world. And I would suggest very strongly that all these people that continually talk to you about compassion do not, in the least, have your best interests in mind. And there are far more virtues and values than an excessive pity for people. You know, you don't want to pity your children even. You want to encourage them to develop in a strong and forthright manner so that they can go out and take on the world. And an excess of compassion just ensures that when they're 40, they're going to be living in your basement, plotting evil routines about the world, because their ability to manifest themselves as successful beings has been absolutely compromised. And I think that we're seeing this played out. We're seeing this played out in society. And I think it's absolutely horrifying. So on October 18th, the university mentioned to me in another warning letter that if personal pronouns are being used, the refusal to use the personal pronoun that is an expression of the person's gender identity can constitute discrimination. So now, you see what's happened is that I haven't refused to use someone's gendered gender-neutral pronouns. I said that I would refuse. So it's not even the refusal itself that's producing the letters. It's my declared intent to engage in the refusal. And as far as I was concerned, what I was essentially doing was criticizing a piece of legislation that had not yet been passed. But the university's legal department decided that all that was sufficient for them to distance themselves from me and to engage in disciplinary activity. So, and then with regards to these human rights tribunals where all of this stuff would be sorted out, it's like those places destroy your reputation and destroy you financially. And can they put you in jail? Well, it's a complicated argument in some sense, but I can tell you that if you refuse to pay the fines, that's the next step. So I think you're being sold a bill of goods here about how benevolent the intent of Bill C-16 is. And I also know, because another lawyer told me that because I suspected that the Ontario Human Rights Commission people were behind all of this legislation, essentially speaking, in Canada. And that's actually the case, because the federal people have indicated that these policies will be interpreted in accordance with the Ontario Human Rights Commission's policies online. And so you guys should go read those, because those are not fun. And I would say that they pose an incredible threat to your liberty. And it's all done under the guise of compassion. It's like, I don't consider myself a particularly compassionate person, let's say. I think I'm more compassionate than I should be for my own well-being. But I can tell you that that is not the only virtue. And people who keep pushing that on you are making a massive mistake. And they're infantilizing you. And they're terrifying people in the university community, as you can tell by the letter that I just read. And I've received dozens of letters like that. People are afraid to say anything because they're going to get targeted. And if you wonder or not if that's true, then just think about what happened to me. And ask yourself if it's true. Good enough.
Thank you.